Good morning, everyone. My name is Anthony Ray, and I am one of the attorneys here at Ray Law International. Welcome today to our webinar about transferring to the United States through your company. I'm the principal attorney here. We have 4 attorneys here. We have 3 offices located in Chicago, Michigan, and New Jersey, where we represent clients throughout the U.S. and throughout the world. I want to thank everyone for joining us today. I'm going to now turn it over to Lauren for a brief introduction.
Hello, nice to see everybody in English and Japanese, I guess. My name is Lauren. I'm one of the attorneys here at Ray Law. I've been practicing immigration law for about 6 years, and I've been with the firm about 3 or 4. So happy to be here with you. If you would like, you can leave a comment for us, and we would be happy to answer it.
Hi everyone, my name is Anaí de la Garza and I am the Client Sales Manager here at Ray Law International. And I'm going to pass it over to Saki now.
Good morning from Chicago. My name is Saki. I'm a legal assistant at Ray Law International Chicago office. Nice to meet you.
Thanks everyone for your introductions. We're going to go ahead and get started today. And one of the first questions is going to be for Lauren.
I'm going to jump in real quick with a brief comment for any of our Japanese listeners today. 質問がある場合はコメント欄へご質問を投稿してください。質問へお答えいたします。また、弊事務所までお電話もしくは E メールにてお問い合わせください。ありがとうございます。Okay, go ahead, Annie.
Thank you, Anthony. So the first question will be for Lauren. And why is a visa needed to be transferred to the U.S. company?
Yeah, well, in order to work in the U.S., you do need some sort of working visa. So there's a difference between just coming to the U.S. to attend a business meeting, in which case, obviously, you could just use the ESTA program or B2 visa, depending on the country which you're from. But in this case, if you are intending to work in the U.S., then you would need a visa in order to have a legal status here, make money here, get a social security number, and obtain all the benefits that come from working in the U.S.
Okay, Saki, if you can ask the next question.
Sorry. Okay, the next question to Anthony. What are some common visa types used by companies to transfer employees to the U.S.?
There are several types of visas used to transfer employees to the U.S. First, we'll go through a few of them. For example, first is the H-1B visa. That's for individuals with specialty occupations, such as engineers, accountants, lawyers, doctors, and other professionals. Usually individuals that require the position requires a 4-year degree or higher. Another one that is commonly used, which we'll touch on today, is the L1A visa. Those are for our executives and managers. Next is the L1B, those individuals possessing specialized knowledge. A few more, E1 for our traders. With certain countries where we have a treaty, you can use the E1 to send key employees to the U.S. E2 for our treaty investors. Next is E3 for our Australian friends, if you're a professional, E3 is an excellent visa category to use to come to the US. And next is the TN visa. A lot of companies transfer their employees from Canada or Mexico using the TN visa. It's very, very helpful and common. So next, there are just now, these are just a few of them. There are a lot of other visa categories. So if you guys can think of them, please, I encourage you, write them down in the chat or in the comment section and let me know what you think some of the other visa categories are that would allow employees to be transferred to the US. All right.
Thanks, Anthony. The next question for Lauren, what are the types of L visas?
Yeah, so Anthony touched on this a bit, but the first would be L1A. That is for managers or executives. So if you're a high-ranking executive, your company can bring you over on L1A. Or if you're just a manager, as long as you're managing at least a few people, especially if they are professionals, definitely speak with an attorney to make sure the managerial structure is correct. But in general, managers can also use the L1A to enter the US. The next would be the L1B. Again, that is for more specialized knowledge individuals. So if we can get into this more a bit later, but in general, if you know a lot about specific practices, procedures, processes, maybe intellectual property of your company, or if you have some sort of knowledge that is very specific to your field, maybe not to the company, but to your field, you could potentially use the L1B to come over. Finally, there is the L2, and that is for the dependents. So if you are coming over on L1A or L1B, and you have a spouse or a minor child is someone who is under the age of 21 for immigration purposes, then those dependents can also come to the US on the L2 visa.
All right. Next question to Anthony. How do I qualify for the L1A visa?
All right. Thank you, Saki. So let's talk about the L1A. So please note that today we'll probably spend a lot of time on the individual side of the L category about the employee and, manager executives and specialized knowledge. But we'll also spend a little time on the employer side and the company relationship a little later, but that's very important as well. So in order to qualify for the L1A, you must have worked abroad for at least 1 year in the past 3 years prior to your entry into the United States to work for the affiliated organization. Now, when you enter the United States under L1A, not only do you have to have one of the 3 categories in your home country, such as executive, managerial, or a position of specialized knowledge, but also when you come to the United States, you're also going to have to fit or take a role or a position in one of those 3 areas. Again, the 3 areas for the L1A is executive and managerial position or a manager. Now, we'll talk a little bit more about the details of how you qualify that and some of the workings of that. But oftentimes, I like to tell our clients that what you in your company designate as a manager is often very different than what the immigration law or the INA requires. So I think the immigration law is a lot more broader, a lot more flexible as to designating people as a manager. So depending on your role abroad in your home country, or if you've been assigned to, for example, Africa or Asia or Europe, depending on that role, we want to look at the 3 years prior to what role did you hold, and it was that a executive or a managerial position. If so, we'll transfer you over to the U.S. You can transfer over into a executive, manager, or a specialized knowledge position. All right, next one.
Turning it over to Lauren. What are the requirements for the L1B?
Okay, so I touched on this briefly earlier, but more specifically, the definition of specialized knowledge is either special knowledge possessed by an individual of the petitioning organization's product, service, research, equipment, techniques, management, or other interests. Those can be considered very broadly if you think that those would qualify for you. You could also do interests in the company's application in international markets, or an advanced level of knowledge or expertise in the organization's processes or procedures. So that can be, let's say you are an engineer and your company manufactures a specific product. This is just an example. Obviously, there could be many, but if you know specifically how that product is manufactured, this is very advanced type of knowledge. Perhaps we could get you into the U.S. on the L1B. Now, also for specialized knowledge, we have to be sure that you would have some sort of unusual qualifications that is not generally possessed by others. Oftentimes we have issues where yes, the knowledge is specialized, but USCIS will come back and say, well, there are a lot of other people that hold this knowledge. We may disagree, but that's kind of the argument that they will use. It has to be also set apart from other employees in your organization. So again, it would have to be some sort of highly specialized manufacturing. In my example previously, not just some sort of, yes, you know the company is manufacturing, but in general, if you move to maybe another company, it'd be the same type of knowledge. Maybe we would not consider that as specialized. So for this one, definitely really important to speak with an attorney. It's not as cut and dry as the managerial position, making sure that the knowledge, what is exactly the knowledge that you're using. We have to be able to specify that really, really well, drill down exactly what that is. And again, like Anthony said, same qualifications as to the time spent with the organization for L1B as for L1A. So again, you have to be working for at least 1 year within the past 3 years before entering the US with your same organization. Now that could be, let's say the parent company is in Japan. Like Anthony said, you could be working for that company in Europe as long as that European entity is related to both the US entity and the foreign entity. Again, there are other employer qualifications, but those are in general for the individual or how you would enter the US.
All right, thank you, Lauren. Okay, next question is to Anthony. Who is eligible for the L2 visa category?
Thank you, Saki. All right, so for the L2 is for dependents of the principal L1A or L1B. Both spouse and children will hold their own L2 status, and the L2 status dependents, is granted for the period of either the L1A or L1B. So for example, if the L1A or L1B is granted their status for 2 years, their dependents in L2 will receive the same period of time. Now, there's a lot of things to be careful about. We always encourage people check those I-94s and the visa stamps in your passport when you come in to make sure that the appropriate amount of time is granted to both the dependents so that there's no overstay of status or or any problems in the future. So the the L2 spouse, not the dependents, the L1, L2 spouse can apply for work authorization during their stay in the United States. That has been a big litigation issue. We will have a video coming out about that probably later this week, so look for that. But yes, there was a recent court decision that impacts certain EAD or people applying for work permits. Now, for both the dependents, both for the spouse and the children, they are eligible to take classes, study here in the U.S. during their time while they reside here. So just keep that in mind. That's all about the L2. If you guys have questions, go ahead, throw those questions in the comment section. Let us know what's on your mind. Doesn't have to always be about the L1, the L category. If you have some other immigration questions, go ahead, type those in. English, Japanese, Spanish, we're ready to take those questions and help you along your immigration journey. All right, let's go to the next one.
Thank you. So the other question is for Lauren. Is there an annual quota on the L1A and L1B?
Simply put, the answer is no. There is no quota for the L1A or L1B. So if your company thinks that you apply, they can petition for you and you can enter the US at any time. So that is an advantage over, say, an H-1B, where you would have to start at the beginning of USCIS's fiscal year, which would be October 1st of whatever year you are in. With the L, as soon as it's approved, you can enter the US and begin your work. No quota there. Thanks.
All right, thank you. So the next question to Anthony. What are some common challenges faced in getting the L1A approved?
All right. So obviously the greatest challenge is the government. You have to overcome the requirements and make sure you clearly meet their guidelines and address any questions they may have. So for the L1A, some of the challenges often come in the form of what we call a request for evidence, or an RFE, as we use in the industry. And in those requests for evidence, there are usually anywhere from 3 to 7 pages of the USCIS asking for additional information. So the greatest challenges we see, or we often see, not always, but often see, may come with challenges to executive or managerial job duties. And the second one is permissible managerial structures. Let me touch on that first one. The job duties. All too often, employers, when they put their job duties together, they're not thinking about all the details of what that individual does. Typically we'll have a manager, they just manage the whole company, and it's just, a short phrase, maybe 5 lines. However, when we submit applications, we have to be very detailed. Remember, the USCIS is looking at this in a vacuum, in some building, in one of the service centers, and they really can't talk or ask questions of the employer. Therefore, it's so critical for us to be very detailed in our job duties. Job duties need to have percentages on there. The terminologies used is huge. Whether you make the widget, or whether you manage the widget, or whether you oversee the making of the widget. All of those are extremely different in the immigration realm. And that's the skill and the know-how or knowledge you're going to need in order to really have the right job duties and meet all the requirements for that. So executive and managerial job duties, very critical. A lot of time needs to be spent on this. The second one is permissible managerial structures. Now, I sort of hit on this a little earlier. I always walk through this with all our clients of what is the managerial structure under the INA, or the Immigration and Nationality Act, which is the immigration law here in the US, and the regulations that guide us. So under there, we really have three options. You usually have our traditional manager, supervisor, and then our um, employee level. That managerial structure is very straightforward, but for some companies, they're not that big, or maybe they don't have that structure. So the next structure would be managing professionals, where you have the manager overseeing professionals. Again, we talked about professionals before, usually positions that require 4-year degrees or a certain high level of expertise, such as engineers, accountants, IT, software engineers, and I mean, there's hundreds and hundreds of positions out there that would fit that option. And the last one, for more so the larger companies, is what's called a functional manager, where you're not overseeing a particular group of people or individual, but you're overseeing a function that's vital to the company. So those are those structures. So those are some of the common challenges. And when you have an attorney on board, they're going to want to pay attention to all of those to make sure that you, in order to make your case successful, that you meet all these requirements.
Thank you, Anthony. So, Lauren, I heard L1Bs can be difficult to get approved. What are some of the issues?
Yeah, so these we do see a lot of issues with. The L1As, as long as we have, like Anthony said, the job duties properly explained and we have the managerial structure properly explained, we can generally say, yes, this will be approved, or no, I don't think this candidate is a good fit. With the L1B, there is a lot of scrutiny from USCIS on this category. In the past, there was some abuse of this category, according to USCIS, so that is their reasoning for putting more scrutiny on it. So while the company may think that the candidate they have, who is an engineer, they think holds highly specialized knowledge, the USCIS may disagree. So same thing with the L1A. We need to have those job duties really well thought out, really well explained. Why is this knowledge different from other employees, both in the industry and potentially other employees in the company? Maybe they hold the same title, but this employee holds very specialized knowledge that is critical to the company bottom line. So very specific job duties. Like Anthony said, we need percentage values on every job duty. What we mean by percentage values is USCIS wants to know how much time does this candidate spend doing X task per day, right? So let's say this person, part of their job duties is just to attend seminars and keep up with their knowledge. Well, that may not be a specialized knowledge task, because many employees need to do that, keep up with their knowledge, but that may be only 5% of the job duties, and the rest of the 95% are extremely specialized. So that's what USCIS wants to know: how many of these job duties are specialized. Obviously, usually 100% of the job duties, what they're doing 100% of the time, can't be extremely specialized, like my example, if they're attending seminars, things like that. But in general, we need to demonstrate that over 50%, the more the merrier, of the job duties are very specialized. We usually like to demonstrate if they hold some sort of specialized knowledge, what type of education do they hold. If they hold a specialized degree, submit those documents. Do they hold a patent in a foreign country in the US? Demonstrate that they hold that patent. That can be extremely helpful to show that the applicant actually holds this specialized knowledge. Usually for the working at the company abroad for a year, that can be pretty easy to demonstrate. We just provide a year worth of pay stubs. So that part isn't too difficult, but it would be more so just hammering down on those job duties and providing the evidence to back it up. With the L1Bs, USCIS is really not just going to take the company's word that this is happening. They are going to expect some supporting documentation, independent documentation that does not come from the company, such as educational documents, such as patents. Maybe there's training records, internal HR documents. Although those come from the company, they are kind of separate from maybe in immigration. They're standard documents that are made in the time that the applicant is working. So those are just a couple things. Obviously there's a lot of issues with the L1B because of the increased scrutiny, but in general, those are what we see.
Thank you, Lauren. Next question to Anthony. What relationship must the foreign and a U.S. company have to qualify for the L1 visa?
All right, thank you, Saki. Hold on just a second. Let's pull that question up. All right, this is where it gets really exciting. Often we focus just on the individual. However, the company relationship is critical in order to get it approved. All too often, and it's not always clear cut. A lot of people say, well, yeah, I own a company in, Pakistan, and I own a company in the US. Do I qualify? Well, it's not as simple as just that. We have to show the legal relationship. And so the terminology that we use in our field is qualifying organization. Now, the qualifying organization can be a subsidiary, branch, affiliates. We even have partnerships for our accounting firms. And in certain circumstances, even religious organizations such as the Catholic Church can also qualify. It all goes down to how these two entities, a foreign entity and the U.S. entity, are connected. There needs to be a strong nexus. The easiest route is, of course, having a legal relationship. For example, owning the stocks or share of the other organization. In addition, we have to show that there's substantial control by one of the organizations. So it's very important that when you start or when you're first introduced to the L category, talk to an attorney, make sure the legal structure is set up properly, and that everything is documented. Can't stress it enough, documentation. You don't want to file the L1 and then get a request for evidence and then have to make some changes or actually document what already took place. So make sure, it's very diverse. It doesn't, it could be a proprietorship, it could be an LLC, it could be an S corp, corporation. All that is good, but that's not key. We want to look at the relationships between the two organizations going back and forth. So that's part of the qualifications. Also, we have to, as I mentioned, document stock ledger, ownership documents, evidence of ownership is often used. Financial documents are really good. Sometimes we have startup companies or new companies that really don't have that history, and we'll get them going maybe under a B first until they get everything set up, and then we'll transition to the L and qualify for that. That's another option. So we get some activity moving forward, and it makes it a little bit easier for the USCIS to go ahead and approve that. One thing to remember, the relationship between the US company and the foreign company, there's always going to be asked, how long has that been? Now, if the relationship has been short, under 1 year, then you're going to be granted the L for only a short period of time, in this case 1 year. Why? the U.S. government or USCIS wants to make sure that this is a legitimate business and it's going to function and work out. Do you have to be making money after that first year? No. They're just checking. We've had companies that jumped into the L, made their investment, and let's say it's a big manufacturing company, and it takes years to get out of the red, to recoup their investment. So it may be 4 or 5 years. So being in the red financially is not a downside as long as you're doing business and moving forward. Now, the other aspects, if you are in business or the relationship has been established for more than 1 year, now we're back to the regular rules and regulations where the USCIS is going to grant your status for 2 or 3 years segments. Now, I don't think we talked about this. I'll leave it to a little bit later. We'll talk about how long you can be in L1 status and L1B status if we haven't talked about that. So that's part of what the companies need to do to qualify. Go ahead, Ani.
Thank you, Anthony. So we're halfway through our webinar now. I wanted to take a moment just to ask a fun question. I'll start off with Mr. Anthony. What is a favorite vacation location from your childhood?
Okay. Let's see. I think sort of our favorite vacations or trips, probably we as a young kid, we took a road trip in the US. And many years ago, we used to have a whole month of vacation during the summer for people working and for the kids here in the United States. So we would take a road trip all the way out to California, and along the way, we would go ahead and see all the famous stops and visit Yellowstone, our Redwood Forest, go through the various places in California, come back through Arizona and Texas. And, it's not always easy being cooped up in a car and have a camper in tow. But I think those are probably the most memorable vacations for us out west.
Thank you. Lauren, what is your favorite vacation from your childhood?
Well, I grew up in the Chicagoland area. So in general, I feel like everyone from Chicago just goes to Southern Florida for spring break. So we'd go to Naples, we'd go to Key West, just anywhere kind of down Southern Florida. I feel like we'd go once a year for a while. So always good to get a tan and get out of the clouds in Chicago. What about you?
So one of my favorite childhood vacations was my first trip to Las Vegas with my best friend when we were still in high school. We were able to experience like Hoover Dam and all the Las Vegas Strip, and it was something that our parents were trusting us to go alone, and we kind of had to prove to them that we were adult enough and mature enough to be on our own. So we have a question in the comments. I'm going to go ahead and ask Lauren, how important the supplemental documentations presenting the candidate's skills and lessons of visa application in addition to DS 160?
Yeah, so the DS 160 is actually going to be after you submit the petition to USCIS and it's approved. So while the DS 160 is important, and obviously you do have to demonstrate to the Department of State as well at your visa interview for the L that you are still qualified, everything that you put in your USCIS petition was legitimate. In general, the Department of State is going to really defer to USCIS unless there's some sort of extreme discrepancy in what you're telling them at the interview. So the USCIS application, including the supplemental documentation, is extremely important. I would be hesitant to even say you could get the L1B petition or maybe even an L1A approved without having significant supplemental documentation supporting your claims. The USCIS does go easier on bigger companies. If you're a massive company like Ford, they're really going to trust you a lot more. and also, if you've done a lot of L's in the past, you know, the USCIS is probably going to trust your application. Whereas, as Anthony said, if there's going to be an initial L application, or if the company is just starting up, there's going to be a lot more scrutiny. So obviously the scrutiny level is going to depend. However, each application should definitely include supplemental documentation, education, even for a managerial application. If you are managing professionals, for example, you would want to provide evidence that your subordinates really are professionals, maybe a copy of their diploma. So definitely speak with your attorney about that, or you can give us a call and do a consultation to discuss your case specifically. The second part of this comment, it looks like, as more duties, roles, and responsibilities are written in the supplemental documentations. So yeah, let's say there's an internal HR document, you got a certification because you passed some sort of training. That would be a really good document to submit to prove that, yes, you do have this training, you did undergo whatever, and learn this specialized knowledge that we are now petitioning for. Oh, and Anthony, did you have anything to add to that?
No, not really. Well, I did have one thing. Based on the question, not really sure if this is just a traditional L petition where you have to file here in the US first and then file for your visa abroad. In certain cases, if you have a blanket, which we'll briefly touch on today, we don't have enough time to go over blanket Ls in our discussion today, but in the blanket L, which is a completely different setup, you are going to have a lot, each consulate has their own style of how they want their packets included. So depending on what your post, the U.S. Embassy or consulate desires, you're going to have to follow that. Some want a lot of documents, some want very few. Also to highlight the more job duties, some attorneys try to put as much in there as possible. And our style has been to be very precise, highlight exactly what's needed and make sure that, the exact language is in there. One, so you don't have any contradictions or have the USCIS use your words or various documents against you in order to try to, deny your case or make it more difficult. So that's just one point.
Okay, so for Lauren, what other company information should be included in meeting the L1 requirements?
Yeah, so in general, we would need to show that the company is a functioning entity. So usually we request some sort of tax return or financial statement that would show, one, that the company is a functioning entity, and then two, that the company actually has the ability to pay whatever wage that they are saying they're going to pay you. We have to, especially if it's a newer company, demonstrating maybe even profit and loss, monthly cash flows. We would also, as Anthony said, need to demonstrate the relationship between the companies. That can be stock certificates, bylaws, any sort of document that's going to show the legal ownership between the two entities is the same and there is a connection. For the foreign and U.S. company, we generally also like to include brochures. Maybe the USCIS hasn't heard of your company. So if you have some sort of brochure that can say, hey, this is what we do, this is what we manufacture, or this is the service we provide, that can really help USCIS understand the context of the L1 applicant's role within the organization. For other documents, any news articles also can be helpful to show that maybe the company is planning to open a plant or some sort of other office or other deals that the company has made, big customers the company has gotten. And that would show that, yes, the company, again, is a functioning company. They're likely going to have the ability to pay, and this person is going to, in fact, be working in that organization. Now I do see that we do have another follow-up comment from Shou Xiang Lim. So Shou Xiang Lim, if your company has a blanket L, we will touch on this a bit later, but since you're with the blanket L, you will be filing directly with the Department of State. There is no USCIS petition. So that is the great part. That's what we love about the blanket Ls, is we don't have to deal with that first step that other companies would have to do, which is file with USCIS. In that case, yes, it's definitely still important that you present your best case, and that your company attorney will be able to advise you on that. But there's going to be less scrutiny, because to qualify for a blanket L, the company needs to be large enough, maybe have a lot of different entities and subsidiaries, lots of L applications. So the consulate is going to be more familiar with the company and trust more what the company is going to say. Let's see if Saki can get her mute button.
All right. Thank you, Lauren. Okay, Anthony, there was a recent court decision regarding the work permits for spouses in L2 status. What happened?
Thank you, Saki. Very good question. And this is some really, really great news. It doesn't help all of us out there, all the spouses out there, but I guess it is really a step in the right direction. One of the things with our immigration law is it's really out of date. It really is. And the USCIS can make things a lot more easier, or a lot more easy if they just implement what came out of this lawsuit. So, there's easy fixes to our immigration system and policy if we want to fix it. Unfortunately, there's not a lot of motivation there. But in this lawsuit, basically a group of spouses who are either in H4, those are spouses of H1B holders, or L2, spouses of L1As or L1Bs. The law provides, as we mentioned earlier, that they can apply for a work permit. However, that work permit processing time by the USCIS has become outrageously long. I mean, anywhere from 6 to 12 months. It's crazy. People are losing their jobs. They can't work. And a lot of these L2 and H4s, these are professionals. We're talking IT professionals and other professionals who are really adding to our American culture. So basically what the lawsuit said, and we were still waiting for all the results. Basically, the nice thing for our H4 EEDs, they're going to allow for automatic extension, which is perfect, up to 180 days. And what that means is, as long as you file timely, and as long as you've maintained your status and your I-94 for that status is still valid, they're going to automatically extend it up to a certain period of time. Again, we'll do a video, get into all the details, but generally automatic extension, perfect. Now, there's a lot of logistics to that. You've got to get the SSA, you've got to get your employer, you've got to probably show them the lawsuit or the regulation from the USCIS in order to facilitate that. But the good thing is you're going to be able to work if you're in H4 status and have an EED filed with the USCIS and it's still pending. Now, for our L2, it's a little bit different, but along the same lines. They're working on the regulations to get an automatic extension also for the L2s. However, we have to wait for our government, our USCIS, to come out with the exact regulations. They're supposed to come out with those regulations within 120 days from the date of the lawsuit. So we should get a lot of clarification early next year. So stay tuned. Stay connected to our page, and we're going to give you updated information of how that's going to impact those. Now, where it doesn't help is a whole lot of other people. The EAD application, or the Form I-765, is used for, at least 20, 30 different categories. And there's a lot of people, everyone from asylum seekers to students to, it's just a lot out there. So for example, spouses of E1, E2, or E3s, you're not covered by this yet. Now, it would be really great if the USA is just broadly gave it to everyone and gave that automatic extension because they are unable to process these cases in a timely manner. But we'll have to wait and see how the USCIS addresses it, not just for the H4 and L2, but for others as well.
Thanks, Anthony. So, for Lauren, the comment section below is saying came to the US under L1B, being promoted to a managerial position after 2 years, then preparing L1A visa by the due date of L1B. No managerial experience prior to the L1B. Would this case qualify to L1A?
I'm gonna jump in. I don't want to get too specific in, giving legal advice on a particular case. Um, so, I would recommend just give us a call. Our contact information is going to be there, and then we'll probably, respond to you offline and give you more details. So, the initial consultation is free, doesn't cost anything. Call us, Lauren and I will address this question and be a little bit more direct for your specific case and situation, all right?
Thank you, Lauren. What are a couple issues that may arise if the L1 visa holder's company is acquired by a new company?
Yeah, so let's say you're holding an L1 visa. If you need to renew your L1 visa, we would still need to demonstrate, again, the company relationship and show that their company relationship still exists. So if the company is acquired by another company, or let's say it's sold and then that relationship no longer exists, well, that might put the L1 visa holders in jeopardy. So very important before there's any mergers, acquisitions, to ensure that that qualifying relationship will still remain. Otherwise, the candidates may have to look to change to some sort of other visa status. Saki?
All right, thank you. So Anthony, so there is no way my company will pay 2,500 for premium processing. What are the regular processing times I can expect when filing my L1 petition with the USCIS?
All right, thank you, Saki. For those who are not familiar, premium processing is a request where you give the government more money for them to do their job within 15 calendar days or more quickly. An RFE can be issued during that period of time, so it's not a guarantee you'll get approved within the 15 calendar days, but your case processing time will greatly increase. The filing fee for premium processing increased to $2,500 last fall. Before it was $1,225. It just gets more and more expensive, and even some of the immigration regulation or bills that's introduced into Congress is also looking to tack on even more filing fees. But right now, the demand for employment or professionals or for these positions is so high that even with some of these filing fees costing between $2,000 and $6,000, employers are willing to pay it because they really, really need workers. So the regular processing time is going to vary depending on the service center you're at. And you have to check the service center. Commonly Vermont, California, Nebraska, and Texas, you're going to see a wide range. It all depends on how busy they are. Often what we try to tell clients is you'll see a range anywhere from 4 to 5 months up to, for example, 9 months. Now, this could change next month. So you have to be vigilant and check up on each of the service center to, see how long it's taking. Also, we're still dealing with a pandemic here. So that impacts things. And, a lot of people are retiring, causing further delays in the government. So a lot of things could be a factor of how long it takes to process. But as a ballpark for our discussion today, I would say anywhere from 4 to 5 months to probably 9 months or so, depending on the service center. Now, the good thing is, before you file, you can look at the processing times on the USCIS website. That's very easy to do. Just select Form I-129 and then your choice of service center so you can get an idea. However, you cannot form shop. What that means is you can't choose where you want your case to go. We get that question almost weekly. It's like, hey, well, California's taking way too long. I want it to go to Vermont where it's quicker. And, a lot of it may just be that they have more space. They have more people in the California Service Center to process more, but they're also handling a lot larger volume than they may be in other service centers. So once your case is filed and you have a receipt number from the USCIS, you'll then be able to check the USCIS website, see what the processing times are. Now, the great thing with premium processing, you don't have to file it initially. You can file it after you file. It can be immediately after you file. It could be 3 months. You can kind of wait and see. Or if you're coming up on some certain deadlines, such as travel or some green card requirement that you're looking at, then you can expedite that to get your case moving forward anytime while your case is pending.
Thank you. So, Lauren, I heard the premium processing is not applied to my spouse and children's L2 application. What is the processing time for the L2 with USCIS?
Yeah, so that is correct. There is unfortunately no premium processing with the L2 petitions. In the past, it was nice because if you filed premium processing at the same time as you filed your dependent petitions, you could have those petitions premium processed. Hopefully they go back to that. But yes, for now, there is no premium processing for the L2s. So for this, it's going to, again, really depend on the service center. It varies also if you're going to do a change of status versus an extension of status. Let's say you entered the US on a tourist visa or some other type of status and you're changing to L2. Some of those are only taking about 4 months to 6 months. Some of the extensions, depending on the service center, it's right now saying 16 months. It really depends on how you're going to be going there. So again, it really depends on the service center for the petition.
All right. Thank you, Lauren. So the next question to Anthony. I am an assistant manager for our foreign company, and I'll be coming to the US in a similar position. Will I qualify for the L1A?
Thank you, Saki. For assistant managers, again, we touched on this a little bit earlier today in our talk today. And although we're running out of time, we're going to, there's a lot more to unravel here, but you may qualify. Now, it all depends on your role abroad. What is an assistant manager? What were the job duties? How it was set up? We often look at the organization chart of the foreign entity, and then we also look at the position coming to the US. Now, if that assistant managerial position is either meets a requirement of manager of one of the 3 forms that we talked about, or even if that position is a position of specialized knowledge, then yes, that's great, but that's only part of it. The second part is you're going to have to show that you're going into a position in the United States that is executive, assistant manager, probably not executive, managerial. We'll have to see what is the structure of the company. Or the third one, assistant manager could be a position of specialized knowledge, such as a researcher, or a scientist. So there's a broad range. So in this question, you most likely will, but we've got to look at the structure on both sides to make sure that where you're coming from meets the regulations, and where you're going to is also going to meet the regulations for an assistant managerial job. What I often tell people is don't get hung up on just the titles. It's the job duties and looking how that person really functions within both organizations.
Thank you. Lauren, is a specialized knowledge standard the same with USCIS and with the US consulates?
So in theory, the answer is yes. They do look at the same exact regulations and apply them. However, it's in that application of that same regulation where we find there is a large disparity. The consulates, that's why we do encourage, if the company is eligible, to apply for a blanket L. That would skip the step with USCIS. The Department of State is going to put a lot less scrutiny on these types of petitions. This matters especially with the L1B, where it can be extremely difficult, even with a lot of supporting documentation and very specific job duties, to obtain an approval. The Department of State, in applying the law, takes a much different approach than USCIS, and that approach tends to be more favorable to our clients. So that can be really helpful there.
Okay, thank you, Lauren. So, Anthony, I heard that being in L1 status can limit the amount of time I spend in L1 status. What are they talking about?
Okay, hold on. All right. So I think this is going to be our last question for today. It's a really great one. So being in H-1B status, how does that impact L-1 status? So the way the regulations work is if you spend time in either of these categories, whether you start off in L and change to H-1B or start off in H-1B and change to L-1, any time in those categories are going to account towards the other limit. For H-1B, as everyone may be familiar with, the maximum time in H-1B status is up to 6 years. For L-1A, the maximum time is up to 7 years. And for L-1B, the maximum time that you can stay in L-1B is up to 5 years. So, quick example, if I start off in H-1B and I work for 1 year, and for whatever reason I need to change to L, then yes, you can change your status from H-1B to L in that second year. However, when you start off in the L, it's not going to be your first year counted. That year in H-1B is going to be counted towards your L-1A, your 7 years, or the L-1B also. Now, this happens for various reasons, company changing structures, flexibility, maybe people want to start the green card process, so they'll go from L to H-1B. Sometimes you can't go from L to H-1B because of the quota. The availability is limited to the 85,000 H-1Bs each year. So there's a lot of things that we have to consider and look at, but working closely with your immigration attorney and HR specialists to come up with a great immigration plan that's going to, be successful, you really, this is where it becomes an issue. So this is what they're talking about, where time in another category, such as the H-1B, can impact another visa category. Anai, go ahead.
So thank you for everyone for joining our discussion today about the L1 visa category. Even though we may not have been able to answer your questions live, we will respond to those questions listed in the chat, or feel free to reach out to us via email or by phone. Now, if there's a topic that you would like for us to discuss in the future webinar, put it in the chat or send us an email. Maybe it will be selected for our future webinar, but you don't have to wait. Contact us with your immigration case. Our next English Live webinar will be Wednesday, December 8th at 11 a.m. Eastern Standard Time. Make sure you subscribe so that you are notified. Our next Spanish Live webinar is right after Thanksgiving on Wednesday, December 1st at 11 a.m. Eastern Standard Time. That's all for today. We will see you next time. Bye.
Bye, everybody.
Bye, thank you.